Hello, I'm Justin M. Kennedy with Litherland Kennedy and Associates, a California estate planning and elder care law firm, and the author of the book, Yes, You Need an Estate Plan. Today, I'm going to discuss whether a person who is not a U.S. citizen is subject to the federal estate and gift tax. The short answer is maybe. U.S. citizens and non-U.S. citizen residents of the United States are taxed the same for the federal estate and gift tax. As of 2023, they will each have a federal estate tax exemption of $12,920,000, and anything above that will be subject to a 40% tax. This exemption amount is per person. So a married couple, even if one or both are not U.S. citizens, so long as each is a resident of the United States, together they can pass $25,800,000 free of the federal estate tax. It is important to note that for both U.S. citizens and non-U.S. citizens who are residents in the U.S., their worldwide assets are subject to the federal estate tax, not merely the assets located within the U.S. This means that in 2023, if you are a U.S. citizen or a resident in the U.S. and you have worldwide assets in excess of $12,920,000, then you may be subject to the federal estate tax. What if you are not a U.S. citizen and you are also not a resident in the United States? Then how does the tax treat you? Well, the federal government would ignore your worldwide assets and only look to your assets located within the U.S. However, non-residents, non-citizens do not receive the previously discussed high exemption. Instead, if you are not a U.S. citizen and you are not a resident in the United States, then you would only be able to pass $60,000 worth of U.S. assets free of the federal estate tax. If you would like to learn more about what assets are considered U.S. assets and what assets are not, then I would direct your attention to IRC sections 2104 and 2105. For non-U.S. citizens, the determination for whether you are a resident or not could have a drastic impact on the amount of your federal estate tax exemption. Generally speaking, a resident is a lawful permanent resident alien, such as a green card holder. But even undocumented people could be treated as U.S. residents if physically present in the U.S. with no present intent to move elsewhere. This analysis would involve reviewing where are your friends, your family, doctors, business connections, etc. It is important to work with an experienced estate planning attorney to help you to understand when you should engage in advanced estate planning techniques to help you to limit your exposure to the federal estate and gift tax. Thank you.